Good afternoon, and welcome to another segment of our Law Alumni Weekend 2020. Thank you for joining us today for the fourth annual lecture and panel discussion on the current term of the United States Supreme Court, presented by experts in Supreme Court and constitutional law matters. We cannot begin today, however, without acknowledging the loss last Friday evening of a giant in American jurisprudence. This week, we have mourned the passing of the brilliant and intrepid Supreme Court Justice Ruth Bader Ginsburg. No doubt her absence will have a profound impact on the court and in our lives. A true champion of democracy, we will always remember and appreciate her for her thoughtful and relentless advocacy and her work on behalf of every American's right to justice and equality. She leaves an indelible mark on American society and will inspire us always to do what is right and to be undeterred in our rigorous pursuit of social justice. Thank you, Justice Ruth Bader Ginsburg. I'm grateful to Professor Paula Johnson and her research assistant Diane Jahangani for their help in producing today's visual tribute to Justice Ginsburg. We have a record audience today, over 600 registrants, and we are in webinar mode, which means that the audience can hear and see all of our presenters and panelists, but our audience's video has not been activated and your audio is muted to prevent noise interference. Although the chat feature is limited to permit today's panelists to convey guidance to all of you during the program, you will have an opportunity to ask questions of our presenters during our Q&A. Please use the Q&A icon at the bottom of your Zoom window to send along your questions. I'd also like to thank our CART reporter, Linda Frost, for her services today, and the Volatus firm for underwriting our live captioning. Any member of our audience can view instantaneous translations of the spoken language during this program by clicking the closed caption button at the bottom of your meeting window. Today's session is planned for 2 hours and 45 minutes, finishing at 4:15 p.m. Eastern Time. A recording of this session will be available on the College of Law's website. I look forward to this afternoon's program as a fascinating and robust discussion of a busy upcoming Supreme Court term. Before I introduce our first speaker, I also want to acknowledge our other sponsors and partners. For their financial support, we thank the law firm of Hancock and Estabrook, the Tully Center for Free Speech, the Institute for the Study of the Judiciary, Politics, and the Media, and the Syracuse Civics Initiative. For its help in organizing this event, we thank the Northern District of New York Federal Court Bar Association, and thanks to my faculty colleagues, College of Law Vice Dean Keith J. Bybee for serving as today's moderator, and to Professor Lauren Golden for leading the production of today's program on behalf of the College of Law. Now I'm pleased to introduce my colleague, Professor Roy Gutterman. An expert on communications law and the First Amendment, Gutterman is director of the Newhouse School's Tully Center for Free Speech. He's a graduate of the Newhouse School and the Syracuse University College of Law class of 2000. And happy 20th, Roy. Professor Gutterman, I turn it over to you.
Thank you, Dean Boyes. I'm honored to be here and honored to welcome Adam Liptak back to Syracuse University. Adam was here as the scholar in residence 10 years ago for the Carnegie Legal Reporting Program. And it's great to have Adam back even in our virtual world as we live today. I'm sure many of us have followed Adam's work at the New York Times as the Supreme Court correspondent for many years. Adam gives us a front row seat not only to the legal arguments before the court, but to the legal issues behind these cases. And Adam follows in the fine tradition of Supreme Court correspondents like Linda Greenhouse and Anthony Lewis. But Adam took an interesting path to the Supreme Court press room through the New York Times legal department. Before becoming the Supreme Court correspondent, Adam had a fine career as a media lawyer and was in the Times legal department and occasionally writing book reviews that led to his current position, which he's held since 2008. There are plenty of lawyers who write and many writers who want to be lawyers. Adam does both, and he does so with clarity for lay readers, non-lawyers, and lawyers to understand these complex legal issues. Unfortunately, Adam can't stay with us for the entire program this afternoon, but he's here now. And join me in welcoming Adam Liptak. Thank you.
Roy, thank you very much. That kind of introduction reminds me of something Justice Scalia would say when someone gave him a fulsome introduction. He would say, "I wish my parents were here. My father would have liked it and my mother would have believed it." Let me see if I can work some technical magic here. And I'm going to, as we all have to, first of all, acknowledge the tremendous loss our nation has suffered with the passing of Justice Ruth Bader Ginsburg, who was an icon not only for her work 27 years on the Supreme Court, but for her path-breaking work on behalf of sex equality as a litigator. To give you a sense of her stature, not that you need it, when she laid in state today at the US Capitol, she was the first woman ever to do so. The only other woman to have been accorded a similar honor was Rosa Parks, the civil rights hero. But since she'd never served in government, she was said to have lain in honor. And the only other Supreme Court justice to have been accorded that honor was Chief Justice Taft, who had also been president. So that tells you something about the stature of the woman we have lost. And it is time for grieving, but it's also an unsettled time in America because it took mere hours for the fight over her successor to begin. And I want to put that fight into a little bit of context by taking you back to February of 2016 when Justice Scalia died. Now note that we have now two presidential contests in a row in which the looming shadow of a vacancy plays an enormous role. When Justice Scalia died, the initial thinking was this would give President Obama, or maybe Hillary Clinton, a chance to reshape the court in a way that would return us to the days of the Warren Court, which was the last time the court had a liberal majority in the 1950s and early 1960s. And if the usual processes had been followed, this was February of an election year, we would have had a court that would likely have overturned Citizens United, the campaign finance decision, District of Columbia against Heller, the Second Amendment decision, sustained abortion rights, sustained affirmative action, perhaps done away with the death penalty. But none of this was lost on Mitch McConnell, who there 2 hours after hearing the news, although on vacation in the Caribbean, made an announcement. And my colleague Carl Hulse, in an excellent book on confirmation battles called Confirmation Bias, has this nice detail. One of the reasons McConnell wanted to move so quickly was that there was going to be a Republican debate that night. And at that debate, it was thought or feared that Ted Cruz would propose the idea of not holding a hearing for any Obama nominee. And Ted Cruz, not the most popular member of the Senate, it's said of Ted Cruz, sometimes people ask, why do people take an instant dislike to Ted Cruz? And the answer is because it saves time. So McConnell didn't want Cruz to be the author of this idea. He wanted it to be himself. Now, ironically, just weeks ago, in the most recent list of potential Supreme Court nominees President Trump issued, among the names was Ted Cruz, which again takes you back to a joke that then Vice President Biden made at a gridiron dinner in 2016. he said he'd advised President Obama to put Ted Cruz on the court because it would immediately result in 8 vacancies. Anyway, Obama didn't take the bait, didn't move fast, in the usual deliberate way, chose a candidate that in ordinary times should have been acceptable to everybody. In fact, Republicans had said that then Chief Judge Merrick Garland of the DC Circuit was the one Democratic nominee that would be acceptable. He was moderate. He was older by Supreme Court standards, quite old, 63. And President Obama thought that that nomination should be given at least consideration. He miscalculated, and he may have miscalculated in a second respect, because if he was going to lose anyway, and he had put up, say, a woman of color, his base and the Democratic base might have been more energized to go to the polls to be upset about the mistreatment that person might be said to have had. Instead, the left side of the Democratic Party was not enthused about Merrick Garland. Hillary Clinton never mentioned his name. And President Trump got a decent amount of play in the election by releasing, and this was quite unconventional, lists of people he would nominate. And it helped him in that election. And this Ginsburg nomination it's such an unsettled, volatile moment, but it's at least possible that it helps him in the current one. Now, a lot of people ask, was the Senate entitled to wait almost an entire year and not give Merrick Garland a hearing? The answer to that, it seems to me, is yes. All the Constitution says is that the president shall nominate and, by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. That suggests to me that that consent can be withheld retail or wholesale. It might not be pretty, but they're allowed to do it. That phrase, judges of the Supreme Court, reminds me of a nice moment at the court where an advocate speaking to Chief Justice William Rehnquist called him Judge Rehnquist. And the Chief Justice bristled and said, "I'm a justice, not a judge." And Justice John Paul Stevens pipes up and says, "Don't worry, counselor. The Constitution makes the same mistake." In the current climate also, there's some reason to accuse Republicans of a kind of hypocrisy. They'd said that presidents shouldn't nominate Supreme Court justices in the final year of a presidential term, and now they seem to have little problem with it. They reason that it matters that there's there was divided government in 2016 and not now, but the constitutional text certainly appears to allow them to move forward with the nomination, as they apparently intend to. We should hear from President Trump tomorrow night at 5, he says, about whom he intends to nominate. And the Senate is planning hearings in October and may be able to confirm somebody by Election Day. If they don't, most everyone seems to agree that even a lame duck Senate could do so. Why do we find ourselves in this situation, this volatile situation, 2 elections in a row? And the answer seems to be that, and the experience of other nations tells us, that our system of having more or less life tenure, the text says shall hold their offices during good behavior, but that amounts to life tenure, allows all kinds of mischief to happen. We have these unfortunate, unexpected deaths, lobbing hand grenades into the political process. We also have justices trying to retire under presidents whose political views they share. So judges whom we would like to be apolitical are put on the court as a consequence of a political process, and then leave the court making political calculations. And however wonderful and majestic our Constitution is, it may have made a mistake in this regard. The rest of the world does one of two things in their Supreme Court analogs, in their constitutional courts. They either have term limits, which is what you see in these circled countries, or they have mandatory retirement ages. And that solves several problems. One is, Justice Ginsburg died at 87. Justice Stevens retired at 90. People slow down. People have cognitive difficulties. It's not ideal to have people of that age making the most important decisions. And as I said, it also injects volatility and politics into the process. If we had one or the other of these things, as really every single advanced country does, either a term limit or a mandatory retirement age, you wouldn't have these surprises. You would know when justices would retire, and it would allow a cooling off, and it would allow the system to work a little more smoothly. People differ on this. My own view is that it would require a constitutional amendment, but legislation was introduced just today to impose term limits, and maybe it's constitutional. Whether constitutional or not, it certainly seems to me to be a good policy idea. This is a slightly dated array of the court we just lost a member of, but it shows you their ages, and it shows you that Ginsburg, Breyer, and Alito would be subject to the usual term limits or retirement ages if we had that kind of system. An interesting point is that the median age of Supreme Court justices when they're appointed has really not varied over history. It's really been right around 52, 53 years old. The leading candidates currently, Amy Coney Barrett is 48, Barbara Lagoa is 52. That's the age at which people.
Is there a way to get it through her Zoom app?
I'm sorry. I heard some noise in the background. A comment. I'm going to keep going. So right around 50 is the age at which presidents like to appoint people. That's long enough where you have a pretty good sense that they've settled into their adult views on jurisprudential matters, but it still gives them a long time to be on the court. Now, in the founding era, if you were appointed to the court at 50, you were not likely to live to 87 or 90. So in a way, actuarial reality has made Supreme Court tenures much longer, and again, strikes me as somewhat problematic. The court also is incredibly homogeneous. And here I might read a passage from a dissent Justice Scalia issued in Obergefell, the same-sex marriage decision. His point was that if justices are going to be making these controversial social decisions, they shouldn't be made by such a homogeneous group. He wrote, take, for example, this group, which consists of only 9 men and women, all of them successful lawyers who studied at Harvard or Yale Law School. Now, Justice Ginsburg completed her studies at Columbia when she followed her husband Marty there, but she wanted to get a Harvard degree. Harvard wouldn't accommodate her to its lasting regret. And with Justice Ginsburg's departure, we now have a classic 4-4 split on the court, 4 from Harvard, 4 from Yale. Those are good law schools. I went to one of them, but they're not the only law schools. And there's something wrong with a system in which you have to check one of those boxes to become a Supreme Court justice. And it gives rise to a kind of snob levity. Chief Justice Roberts, appearing in a law school not too long ago, was asked, is it true that all Supreme Court justices went to elite law schools? And he says, no, some of them went to Yale. If Amy Coney Barrett, the seeming frontrunner, is nominated, she will change things. She's a very distinguished academic and a federal appeals court judge, but she attended Notre Dame. Let me continue reading from Justice Scalia. He said, this was true at the time, 4 of the 9 are natives of New York City. So Scalia was from Queens, Justice Ginsburg was from Brooklyn, and she liked to remind people the notorious RBG was a play on the notorious BIG, the rapper. And Justice Ginsburg used to say they had something in common. They were both born and bred in Brooklyn. We're now left with only 2 boroughs represented, Justice Sotomayor from the Bronx and Justice Kagan from Manhattan. To continue reading from Scalia, 8 of them grew up in East and West Coast states. Only 1 hails from the vast expanse in between. That's changed a little bit with Justice Gorsuch from Colorado. Not a single Southwesterner, or even, to tell the truth, a genuine Westerner. California does not count, he said. Not a single evangelical Christian, a group that comprises about 1/4 of Americans, or even a Protestant of any denomination. Indeed, Justice Stevens was the last WASP to serve on the court, so this is extraordinary, a court that for centuries was dominated for much of the time, wholly made up of white Anglo-Saxon Protestants, now has, depending on how you count, 6 Catholics and 2 Jews. Justice Gorsuch appears to have been raised Catholic and seems to be attending Episcopal services now. It's also the case that the court is incredibly highly credentialed. You not only have to go to one of these fancy law schools, but more and more, it's like an inherited aristocracy, because most of the justices now, and Barrett herself would be similar, having clerked for Scalia, most of the justices now were themselves former Supreme Court clerks. Another quality in the current court, which is different from history, is that there is a so-called norm of prior judicial experience. With the exception of Justice Kagan, who was nominated to the DC Circuit but never got a hearing, every single justice was a former federal appeals court judge. And Judge Barrett, of course, serves on the 7th Circuit, so she would continue in that line. Now, that's a contrast to, say, the court that rendered the decision in Brown against Board of Education, probably the most important judicial landmark in the history, maybe Marbury against Madison. But Brown is a universally admired decision. And it was written by Earl Warren, who was a former governor of California, joined by Hugo Black, a former senator, Felix Frankfurter, a former law professor, William O. Douglas, who'd been chairman of the Securities and Exchange Commission, Robert Jackson, who'd been attorney general. Consider how very different that is. Those people had large public lives and a deep understanding of the currents of society, and not this kind of highly credentialed, almost bureaucratic, striving personality who makes it onto the Supreme Court these days. It's I'm not sure which is right, and Chief Justice Roberts has spoken about how the heavily legal backgrounds of current justices makes them more likely to make decisions based on law, not policy. But I think many people would agree that we've lost something by not having people, by not having statesmen and stateswomen with broad experience on our Supreme Court. It wasn't too long ago that confirmation hearings were a little more routine. Consider Justice Ginsburg herself, who was a card-carrying member of the ACLU, an avowed feminist, a leading litigator for sex equality, and yet she was confirmed by a 96-3 vote. Justice Scalia, who used to say, everybody knew I was conservative, but they thought I'd be a good judge. They thought I was able and honest, and he was confirmed 98-0. Fast forward just a couple decades, and you see that Justice Kagan's vote much closer, 63-37, and Justice Alito's vote, 58-42, was within the margin of the filibuster, which still existed at that time, although not employed. So we have entered a different era in how contentious Supreme Court nominations are. And we're about to see another one. And it's not good for the court, not good for the nation. But given the hardball tactics that, in fairness, both sides have employed, it's hard to know how we ratchet this back. And I think there is now, I wouldn't have said this 2 weeks ago, there is now a decent chance that if the Republicans ram through a nomination in the waning days of a Trump administration and the Democrats capture the White House and the Senate, that they will expand the size of the Supreme Court. The size of the Supreme Court is not set in the Constitution. It's a matter of statute. It's gone up and down. It's been as few as 6, as many as 10. And there will be a real movement on behalf of Democrats who will say, you can agree with this or not, that Republicans have stolen 2 seats to expand the court, to take account of that, and put liberal justices on in the expanded seats. And that will be terrible for the court and will start a kind of tit for tat that will undermine its legitimacy. And yet it's a real prospect. Let me talk a little bit about where the court is now ideologically. The story of this current Supreme Court is the story of John Roberts. We call the court by the name of the Chief Justice who presides, so since 2005, it's been the Roberts Court. But for almost all of that period, the swing justice on the court was Justice Anthony Kennedy. And Chief Justice Roberts was in a sense in his shadow. Since the retirement of Justice Kennedy 2 terms ago, Chief Justice Roberts has taken the middle seat, the ideologically median seat at the court. So he is, for the first time since 1937, both Chief Justice and the median justice, and that makes him extraordinarily powerful. He was in dissent in the last term only twice, and you see in these charts that he has taken full command of the court. So that's a big change. This is an array of the court's members ideologically. If your screen looks like mine, Justice Thomas is hidden because he's that far off to the right. But what you see at the court is a kind of soft middle, with the Chief Justice in the center seat, but Justices Kavanaugh and Gorsuch pretty close, which means the general dynamic on the court is that it will, in the most controversial cases, often divide 5-4 with the 5 Republican nominees to the right of the 4 Democratic nominees. Let me say also, this phenomenon feels normal in a way, that you can predict the ideology of a justice by the party of the appointing president. It's brand new. It's a phenomenon that didn't exist before 2010. We've had no closely divided Supreme Court in the history of the nation about which you can make that statement, that partisan affiliation equals voting record. Recall that Justice Souter, Justice Stevens, Justice Brennan, Justice Warren, all Republican appointees, all liberals. Going the other way, it's harder to find examples, but Byron White, a Democratic appointee, generally quite conservative. Now, if Judge Barrett were to be confirmed, I would expect her to be somewhere to the right of this soft middle. And that would, if nothing else happened, thrust Justice Kavanaugh into the center seat and withdraw some power from Chief Justice Roberts. But this would be a dynamic process, and I would expect the Chief Justice, who has in some major cases on healthcare, on abortion, on the citizenship question added to the census, on DACA, the program that shields young immigrants, occasionally joined the court's liberal wing. I would expect him to do that less often. One of his distinctive powers is the power to assign the majority decision when he's in the majority. That's a power you don't give up lightly. You can assign the decision to yourself or to one of your allies and shape the law. So the idea that if there's a sixth Republican appointee to the court, that the Chief Justice would continue occasionally to join what had been 4 liberals and form a majority, that he would join 3 liberals in dissent seems less likely to me. This graph shows that the Chief Justice has, over his 15 years on the court, moved substantially to the left and is far to the left of Justice Alito, who was appointed essentially simultaneously with him. I don't know that that trend will continue, but I think what is telling is that Alito and the Chief started in the same place ideologically and have drifted apart, and I have a reason to offer, at least an idea for you to think about. When Chief Justice Roberts was initially nominated to the Supreme Court, you'll recall, he wasn't nominated to be Chief Justice. He was nominated to replace Justice Sandra Day O'Connor. But Chief Justice Rehnquist died, and President Bush switched over the nomination. My hypothesis is that an Associate Justice Roberts would have been a more consistently conservative vote on the court than Chief Justice Roberts, who takes very seriously his responsibilities as the custodian of the Supreme Court's prestige, authority, legitimacy, and that calculation at the margins enters his thinking as it would not have for an Associate Justice Roberts. Let me turn to some cases, and I don't have a ton of time, and I want to save lots of time for your questions. But this is one of the things we've lost in the pandemic. This is, of course, the running of the interns. When the big decisions come out and the TV reporters set up outside, you know it's June at the Supreme Court with the running of the interns. Now, of course, the court, like the rest of us, has not been going to work. It canceled its arguments in March and April, ordinarily the last sittings of the term, and it heard for the first time arguments by telephone in May, 10 of them, and allowed the public to listen in live. That last development I thought was just terrific. It showed the public that we have a court that functions much better than the other branches of government, that these are people who are well prepared, able, thoughtful, for the most part open-minded, and who operate based on reason and facts, which are not qualities that you see everywhere in our government. The telephone arguments also featured, because they went in order of seniority and everyone asked questions from Justice Thomas, who ordinarily is silent in arguments from the bench, and as is well known inside the court, but maybe less well known outside the court, he's a terrific lawyer and asked excellent questions. At the same time, it was a little frustrating to cover arguments by telephone in this format because there wasn't the kind of free-for-all back and forth that let the justices interact and in a way actually start the deliberations, which is what part of the function of a Supreme Court argument. Rather, it was a forced march through brief back and forths one by one, and harder to tell what was really going on. I'm just going to run through a couple of the interesting cases last term. This is Henry Fonda, of course, from 12 Angry Men. The Supreme Court, in a case called Ramos, considered whether you could be sentenced to prison by 10 angry men. Louisiana and Oregon have laws that allow non-unanimous juries, and the court said those laws were unconstitutional. The vote was 6-3, and an interesting aspect of it was the three dissenters, Alito, Roberts, and Kagan, said, maybe it's not a great idea, but we have a precedent that calls for this, and we don't have a good enough reason to overturn that precedent, so we should keep it in place. And I think that was an attempt by Justice Kagan, who's the most strategic thinker on the left side of the court, to try to make sure that Chief Justice Roberts in particular, who was at the time the swing vote, took precedent very seriously for reasons I don't have to spell out. The court also surprised a lot of people by expanding gay rights. When Justice Kennedy left the court, there was some fear among proponents of gay rights that the trend toward greater protection for gay and lesbian people would fall away, because Kennedy had written all four of the landmark constitutional decisions on gay rights, including the Obergefell same-sex marriage decision. So with his departure, there was a lot of trepidation that when the court looked at not a constitutional but a statutory question about whether the Civil Rights Act of 1964 in prohibiting discrimination on the basis of sex, the question was, does that phrase also apply to gay and transgender people? The fear was that the court would have an easy time of saying, listen, nobody in 1964 thought that it did, therefore, end of story. But Justice Neil Gorsuch, who is a committed textualist, meaning what he cares about is not what lawmakers might have intended, but what the words of the statute say, ruled, writing for a 6-justice majority, including the liberals and the chief, ruled that the logic of the law means that you can't take account of sex in deciding to fire or not hire somebody, and that you have to take account of sex to discriminate against gay and transgender people. So that was a big and to many surprising gay rights victory last term. One of the cases came out of the Second Circuit. It involved this gentleman, Don Zarda, who was fired after someone he was a skydiving instructor. And a woman he was skydiving with expressed some concern about being strapped to him. And he said, don't worry, I'm 100% gay. But that apparently didn't play very well with his employers, and he was fired. He sadly died in a base jumping accident. This is Amy Stevens, who was the plaintiff in the transgender case. And she also died not long before she achieved a real victory for transgender rights, the first victory for transgender rights at the Supreme Court. The court also decided a case I mentioned a second ago about DACA, the program that shields about 700,000 young immigrants and allows them to work. And here you saw an aspect of Chief Justice Roberts that I think is completely consistent with his training and his personality. He's a very good lawyer, and he served as the principal deputy solicitor general, and he served in the White House, and he has no patience for legal sloppiness and legal shortcuts. And what he found in the Trump administration's efforts to rescind DACA, which was of course an Obama administration program, was that they just didn't do it right, that they didn't give adequate reasons, that they didn't take account of important reliance interests. And he joined the court's 4 liberals in saying, we're not saying you can't do it, but if you're going to do it, you got to do it right. And as a practical matter, that means that in the next administration, if it's a Trump administration, we might well see DACA rescinded. If it's a Biden administration, of course we won't. But the Chief Justice has his doubts about the quality of some of the legal work that comes out of the Trump administration. We saw this last term also, when a similar question arose over whether the administration could add a question on citizenship to the census. And the Chief Justice, again, joining the four liberals, said, maybe you could, but you have to give a decent reason. And the reason they gave that they wanted to enforce the Voting Rights Act, not an effort you usually associate with the Trump administration, was the Chief Justice found a pretext. So that gives you a sense of the Chief Justice. And that's how the ruling came out. You'll see the public opinion numbers down at the bottom show very strong public support for the program. The Chief Justice also faced a real task in figuring out how to bring his court together to a degree in two cases involving subpoenas seeking President Trump's financial records. And it's really to the Chief's credit that he managed to command 7-2 majorities, each of them including Trump's two nominees, Justices Gorsuch and Kavanaugh. You'll remember that the Nixon tapes case was unanimous, with all three Nixon appointees joining it. Clinton against Jones, the case on whether a sexual harassment lawsuit could go forward against President Clinton, also unanimous, also including both of President Clinton's nominees. And for the Chief in this climate on this court to get 7-2 decisions was an achievement. Now, many people will say, yeah, but the subpoenas haven't yet produced any information that the public can see. And that's true as far as it goes. But they were nonetheless major statements on political power and presidential power. And the case involving Congress is hard to know how it will come out. But the case involving a subpoena from Cyrus Vance, the Manhattan DA, is very likely in the fullness of time to produce documents. And the statement that no one is above the law, that the president is not above the law, was a significant development at the end of the term. The final case from last term I'll talk about also involved the Chief Justice, and it really tells you several things about him. In fact, a question that all watchers of the Chief Justice ask is he a closet liberal? No. Is he a master strategist? Yes. Does he use his opinions to plant seeds that can ripen in later cases? Yes. Is he playing a kind of three-dimensional chess? Maybe. Is he an umpire who calls balls and strikes? I leave that to you to decide. This case involved a Louisiana abortion law that required doctors performing abortions to have admitting privileges at nearby hospitals. Most people think that requirement does not confer any real benefits. You already have, having admitting privileges is essentially a business relationship between a hospital and a doctor. Since abortions are safe and don't give rise to many admissions, many hospitals aren't interested as an economic matter. Other hospitals aren't interested in being associated with abortion providers. So the real purpose of these admitting privileges laws seems to be to shut down clinics. And Louisiana would have gone from 3 clinics to just 1 had this law gone into effect, a trial court found. The exact same law was considered by the court in just a couple terms ago. And the court that law was from Texas, and the court struck it down. So it was sort of odd that they'd be coming back at this issue, and cynics might think that they were coming back at this issue because there'd been a change in personnel at the court, and Justice Kavanaugh had replaced Justice Kennedy. The Chief Justice joined the liberals, didn't adopt their reasoning, but voted with them and said, listen, I dissented last time around, and I may not think these laws are constitutionally problematic, but we have a precedent, and I'm going to abide by precedent. In the process of that decision concurring in a judgment, most people think he also altered the standard by which abortion laws are to be considered. So he may have moved the needle a bit. But at the same time, it does seem like it was what Justice Kagan was hoping for in that jury unanimity case, that the Chief Justice would take precedent seriously. I think with that, I would love to turn to your questions. Thank you for your attention. I wish I could be with you in person, but I hope that was a decent overview about where we find ourselves in this very interesting climate.
Hi, Adam. Thank you so much for that terrific presentation. I am Lauren Goulden. I'm the Associate Dean for Faculty Research at the College of Law, and I am the Director of our Civics Initiative. And I have 3 responsibilities during this part of the program. First, I get to applaud on behalf of a much larger virtual audience of people from around the country.
Thank you, thank you.
Yes, I can't make it loud enough, but we are also appreciative that with everything that's going on, you're taking time to participate in this event. I know you and I have joked that this is a much different event than we were imagining last January when we started to talk about it. My second responsibility is for the folks taking this for CLE credit. I need to give the code for the lawyers in the audience. This is the first code that you need to log on your affirmation forms. That code should also appear in the chat box. It's SU25. Again, that's SU25. And then my third responsibility is to help manage our virtual Q&A. So I'm going to read some questions that have come in from the audience. And the first relates to what you already talked about, the sort of format of arguments since the pandemic started. And one of the questions, several questions related to this, and maybe I'll make this multi-part. When the world comes out of the pandemic, to what extent do you think telephone arguments, live audio streaming, and perhaps one day camera and video streaming would be part of the court's future? A related question was about whether you think this new format has had any impact on the outcomes of any cases. And I would add, I think maybe just hearing a little bit more about how it changes your work.
Okay. All right. You may have to remind me if you're going to ask me these compound questions. So going forward, the court is really allergic to public access. And until these telephone arguments, what they would do is they hold arguments Monday, Tuesday, Wednesday, 2 weeks a month. And they would release transcripts quite quickly, but not release audio until the Friday after the Monday, Tuesday, Wednesday, just late enough to make it of little use to radio and TV. And I've never understood that. And if you're going to release it, why not release it the same day? Why not go live? And I think there's a decent chance that when they get back on the bench, given that they're already releasing audio at some point, they'll either release it right after, which they've done about 20 times since Bush v. Gore. In really big cases, they have had same day, but not live audio. Or they may find that there's nothing wrong with live audio. If it's coming out anyway, maybe let it come out. And that would be all to the good. The chances of TV coverage are 0 in our lifetimes. They're just not interested. They don't want to see clips of themselves on YouTube and on late night shows. And they are capable of, giving goofy hypotheticals. that don't make them look good. There have been occasional protests in the courtroom that would be more likely, I think, if there were camera coverage in the courtroom. Now, let me say, I think, and they also value their privacy and they don't want to, be accosted at the Whole Foods. I should say my own view is that all of those reasons are unprincipled, that citizens in a democracy have a right to see their government at work if the proceeding is otherwise open. But I don't think that's going to happen. Do I think the telephonic arguments altered outcomes? It's really hard to know, but it can't help. Two problems. One, they came very late in the term, so less time for people to exchange drafts. They have less ability to deliberate either in the context of the argument, which is really, in large part, it's a kind of kabuki dance. They're not really asking questions of the advocate. They are discussing the case for the first time by talking through the advocate. So John Roberts, who was a very distinguished Supreme Court advocate, said that his role was basically, when he argued before the court, was to be a basketball backboard. Try to get in the game sometimes, but basically have things bounced off of you. So I think it probably made it even a hard job even harder not to have that. And then I think you had a third part to the question, and I'm pleased with myself to have remembered two.
Yeah, you're hanging with me. I was curious about how it changed your work in interpreting the arguments, the sort of serial questioning at the end, and whether you think that may change in the coming term, whether they would find a different format where they can interrupt each other like they like to.
I don't think they can do better than, they're not going to do a Hollywood Squares Zoom conference. And I don't think you can have a free-for-all on the phone. I don't think. How did it change my work? In a way, I mean, listen, on the one hand, when you go into the courtroom, you can only take pen and paper. When you're covering the court at your desk, you can record it, you can start writing your story, but you lose something. It's a little harder to pay attention. When you're in court, it's sort of like being in church. You got nothing else to pay attention to. You're not distracted by your phone or anything else. You're just looking at the justices. And you also pick up not a little information by body language and how the other justices are reacting, whether there's some eye rolling when, some question is asked. So you lose that. So it's a mixed thing. I miss going to court. I miss my colleagues in the press corps at the court. And we would, after an argument, typically have a robust discussion about what just happened. So you're kind of much more isolated. It's not horrible. It's a lot better than some possible alternatives, but it's not good either.
Another set of questions related to what to expect after the election, whether the court is prepared for post-election battles, whether you think they've learned lessons from 2000.
Justice Breyer did a talk at George Washington Law School earlier this week, and he was asked that question, and he said, and I don't know how it could be different, that there's no way to prepare because you don't know what the case is. You don't know what the dispute is going to be and who's going to raise it and how it's going to come. But is there a decent chance that we'll have post-election disputes reaching the Supreme Court? Sadly, yes. How will the court react? I think the Chief Justice, as I mentioned in my main talk, will be eager to try to make the court seem apolitical. So he will work hard to try to have not Bush v. Gore redux, where the four conservatives outvoted the five conservatives outvoted the four liberals. Here it would be even worse because that court at least was not marked by partisan affiliation. You had Souter and Stevens on the court, who Republican appointees were in the court's liberal wing. So it would be a hell of a thing to have a 5-4 or a 6-3 if Judge Barrett, say, gets on the court decision in favor of President Trump.
So I have a couple of questions about the potential Amy Coney Barrett nomination. How would the court look different if Lagoa is nominated instead of Judge Barrett? I think people wanted to hear a little bit more about that. There were a couple questions along those lines.
So Lagoa's record is thin. She served on a mid-level Florida DCA, District Court of Appeals, since 2006, and then touched her toe for a second on the Florida Supreme Court and has been on the 11th Circuit for less than a year. And we don't know a lot about her record, and that scares some conservatives who, not knowing her very well is not a good thing to them. The one major case Judge Lagoa voted on was the felon disenfranchisement case out of the 11th Circuit, which there are various ways to characterize it, but let's say Florida voters by a hefty margin wanted to re-enfranchise people with felony convictions. Florida legislature, dominated by Republicans, said, okay, but they have to pay their fines and fees. And those fines and fees are often impossible even to figure out what they are. Judge Lagoa, along with 4 other Trump appointees in a 6-4 decision on the 11th Circuit, said that Florida law was fine. So we know one thing about her, and we know one thing about her in the context of election law. Amy Coney Barrett has a much more robust record. She's been on the 7th Circuit for 3 years. I've been spending the last couple of days reading her opinions. They're of high quality. They're consistently conservative, but they're Supreme Court material. And she was a distinguished academic too, and a law clerk to Justice Scalia. So there's reason to think that she's the leading candidate.
I think there are a number of different questions that want you to make predictions about Roe versus Wade and the abortion cases, whether the abortion issue might block Coney Barrett from, it might really mobilize voters.
Well, will it block her or will it boost her in the Senate? I leave that to you, but there's little doubt. I mean, listen, we don't have a direct statement from her. We have bits of evidence. We have the fact that President Trump has vowed to appoint justices ready to overrule Roe v. Wade. We have the fact that anti-abortion groups are completely championing her nomination. There's good reason to think that if the question of Roe were to come before her, she would be a vote to strike it down. She's written about stare decisis in the context of Roe, and she's indicated that there are fewer reliance interests in retaining a precedent that has continued to be as controversial as Roe has. So I think she could well be a vote to strike down Roe should that direct challenge reach the court. I don't think even with a 6-member conservative majority, the court is eager to take on that question anytime particularly soon. The court is much more likely to take on cases that will chip away at or hollow out the right to abortion. It would be a cataclysmic event in American judicial politics to overrule Roe, and the court's not going to be sprinting in that direction.
There was one question, I think this might be more of a comment. Isn't Justice Thomas as far to the right on your chart as Justice Sotomayor is to the left?
Well, I think that's fair. Yeah. I was making that half joke only because he was
Falling off your
on my
chart.
screen. But really, the middle of the court has 2 ideological outliers, Thomas and Alito on the one hand, and until a week ago, Ginsburg and Sotomayor on the other. And the real middle of the court where the work gets done is Breyer, Kagan, the Chief, Gorsuch, and Kavanaugh.
Another question was about whether you see other justices whose opinions have reflected the same concerns about the court as an institution as Chief Justice Roberts' opinions.
I think it's a subtext of almost everything they do. It was not the subtext, but the text of the 3-justice decision in Casey, which reaffirmed the core holding of Roe, that the court's legitimacy is at issue if it takes a U-turn simply because of a change in personnel.
So do you think there's any discussion about how individuals, judges are nominated and the occasional controversies there, or does that really disappear once they become confirmed?
That's a good question. And, we don't have a lot of visibility into that. But after the brutal confirmation hearings for Justice Kavanaugh, several justices made public comments saying he's part of the family now. Whatever happened then happened then. Being on the Supreme Court is not like being on a circuit court where you serve in different panels. You are part of an arranged marriage with no possibility of divorce. And it really makes no sense to be making enemies. Now, that's not to say there have not been Supreme Courts on which people hated each other. But the current court, the justices all say this, but I also believe them, is reasonably collegial. And people like each other on a personal level. People always talk about the famous friendship between Justices Ginsburg and Scalia. But Justice Thomas, for instance, adored Justice Ginsburg. They're very close.
Some questions about particular cases. One of them is, one question actually is about whether you think, what you think it bodes for the Americans with Disabilities Act if we shift to a 6-3 conservative leaning court.
I'm going to guess the question is about the Affordable Care Act, even if it said ADA. I'm going to think it's the ACA case.
There are a number of questions about the ACA, but I have colleagues, we have strengthened disability law at SU, so I actually, there are a number of questions who want, trying to ask that, but I'll take an answer to either of those.
I'm going to answer the one that I know how to answer. Yeah, the week after, 1 week after Election Day, the court's going to hear the third major challenge to Obamacare, the Affordable Care Act. And the theory of the case strikes me as far-fetched, but it won in the district court, it won in the Court of Appeals, and had we not lost Justice Ginsburg, I would think that at a minimum, Chief Justice Roberts would again join the 4 liberals to sustain the Affordable Care Act. I think even now, and even if Judge Barrett, who's been somewhat critical of the Chief Justice's 2012 opinion in the NFIB case, I don't think they're going to strike down the whole law. There's a kind of trivial question at the heart of the new case about whether zeroing out the penalty for the individual mandate makes the mandate unconstitutional. Maybe it does, maybe it doesn't. But the heart of the case is, does the entire law have to fall as a consequence? And in this last term, in 2 important decisions, the court took a narrow view of severability and said, if we can excise a problematic provision from the rest of the law, we're going to do so. And that's what I expect them to do in that case. Famous last words.
So I think you can tell that I'd like to keep you here all afternoon, and I know that you can't do that. So I'm going to have us wrap up. I just want to say thank you again. This has been tremendous, and we really appreciate you spending this time with us. We now will take a short break so people can stand and stretch before we will return for the afternoon panel, which is going to be moderated by my friend and colleague Keith Bybee, our Vice Dean at the College of Law, and the Paul E. and Honorable Joanne F. Alper Judiciary Studies Professor. Keith also holds a tenured appointment in the Maxwell School of Citizenship and Public Affairs and directs the Institute for the Study of the Judiciary, Politics, and the Media. His other honors, publications, and current projects are highlighted in the participant bios that are in the materials that you have and that should be linked in the chat box. I can drop that link in there again. Keith is going to start the program at exactly 2:45. I'm going to say a quick thank you to my civics fellows, Catherine, Mariah, and Marina, for pulling together those materials. And another thanks to Paula Johnson, Professor Paula Johnson, for her work pulling together the slideshow that opened the program. We're now going to show an extended version of that slideshow during the break. So thank you all very much. Thank you, Adam.
Sweet Lord, Good afternoon, everyone. Good afternoon. Welcome back to our Supreme Court preview event. We are going to be continuing now with our panel discussion. My name is Keith Bybee. I am a Vice Dean here at the College of Law, and we've gathered together a group of distinguished panelists to discuss different cases and themes for the Supreme Court's upcoming term. In the materials that you have and a link that's been circulated in the chat, you can see more extended biographies of each of our panelists. Let me just give you very quick introductions now. We have R. Reeves Anderson, Supreme Court litigator at Arnold and Porter. We have Upneet Bhatti, who's a managing associate at Orrick, Harrington, and Sutcliffe, and also a graduate of the College of Law, 2015. Happy fifth reunion. We have the Honorable May D'Agostino, who's at the U.S. District Court for the Northern District of New York, also a College of Law graduate, class of 1980. Professor Paula Johnson, who's a professor here at the College of Law, and the Honorable Rosemary S. Pooler of the U.S. Court of Appeals for the Second Circuit. Let me just say a few quick words about how we'll proceed with this second half of our program. Each of the panelists will speak in turn, and they'll speak in the order that I've just introduced them. After the last panelist has spoken, we will have Q&A with you, the audience. We'll be using the same Q&A function that we used for a very informative lecture by Adam Liptak. So you'll see the Q&A icon at the bottom of your screen. And you can just click on that and enter questions. I will read them to the panelists and give them opportunities to respond either individually or collectively, depending on the topic of the question. Before we begin Q&A, I will announce the second code that those attorneys who are participating in today's events for CLE credit will need for their affirmation forms. So that second code I will announce after the last panelist, but before Q&A begins. So without further ado, let's begin with our first panelist, Reeves Anderson.
Good afternoon, and thank you, Professor Bybee and Professor Golden, for inviting me back to this great event. Among other things, it motivated me to finally get a haircut, so my family thanks you too. Like many of you, I spent a lot of time this week reading the tributes to Justice Ginsburg. I was especially drawn to the stories reminding us that Justice Ginsburg was a legal giant on both sides of the podium. So before she was the notorious Justice RBG, she was the tireless advocate Ruth Bader Ginsburg. She stood at the Supreme Court podium 6 times, arguing for equal treatment and civil rights. And that experience probably explains why, after taking the bench, she never lost sight of the fact that we as advocates play a role in developing the law and facilitating the court's work. So I happened to be in the courtroom in 2013 when Justice Ginsburg read her famous dissent in the Shelby County case, the voting rights case. In her remarks, Justice Ginsburg reminded us that the arc of the moral universe is long, but it bends towards justice. Then she added her own caveat to the famous quote, saying, "But only if there is a steadfast commitment to see the task through to completion." Few lawyers have done more to bend the arc or shown deeper commitment to the task from both sides of the podium. So in honor of Ruth Bader Ginsburg, the advocate, I want to use this opportunity today to look at the upcoming Supreme Court term from the advocate's perspective. To me, that means the court's workaday business, those cases you probably haven't heard much about. Each Supreme Court term begins with the same headline: 5 blockbuster cases to watch. Sometimes there's 6. Maybe Adam would go after it and get that 6th one. The cases are undoubtedly important and perhaps even historic, but they're also outliers statistically. The Supreme Court decides between 60 to 80 cases each year. That means that over 90% of the Supreme Court's cases definitely are not blockbusters, but they're important and they can teach us a lot about the court. So let's look at 2 of them: Hungary versus Simon and Germany versus Philip. The facts are similar in both cases. The plaintiffs are individuals who were persecuted during the Holocaust or the heirs of those victims. By way of a little bit of background, US courts don't have jurisdiction to decide personal injury claims against foreign governments if the injury occurs outside of the United States. So these are property cases. They allege that the property was taken by German or Hungarian government officials during the Holocaust, or that they sold the property under duress. So think artwork or personal belongings. Both Germany and Hungary argued that the plaintiffs should be required to exhaust their available remedies in Europe before suing in the United States. They argued that the common law doctrine of international comity, or the respect and cooperation that each nation owes to each other, that requires that home countries have the first opportunity to redress the wrongs. The DC Circuit disagreed and allowed the cases to go forward. Because the Seventh Circuit had reached the opposite conclusion, there was a circuit split and cert was granted. So there's two questions before the court this coming term. The first one is that comity question. Can a US court ever decline to hear a property claim against a foreign government in deference of the foreign country's domestic framework for handling those claims? The second issue in the case concerns whether the property was actually taken in violation of international law as the statute requires. So the question is, does a foreign government violate international law when it takes property from its own citizens within its own borders? So sorry to disappoint anyone, but I'm not going to predict how the court's going to decide those cases. So you can tune in on December 7th for the oral argument if you want a preview. Instead, I picked these cases because to me, they illustrate three broader principles or themes that cut across the Supreme Court's docket. So first, the Supreme Court lately doesn't seem to like rigid legal tests. So recall that the DC Circuit said no comity defense under any circumstances. That's pretty rigid. So we see the trend away from rigid tests, particularly in the court's intellectual property cases. In eBay, in last term in Romag and Booking.com, the court seemed to always rule on the side that was advocating for a more flexible legal test. That's not to say that one approach is better than the other. Multi-factor or flexible tests, they leave room for a wide variety of circumstances, recognizing that one size doesn't fit all. On the other hand, clear, bright line rules lead to predictable outcomes, and they may be necessary in an area of law where clarity is key. But on the whole, I'm seeing a trend where the Supreme Court is tending in favor of flexibility. So takeaway one, if you see one side of a case pressing for a rigid test, Supreme Court seems to be skeptical these days. The second feature that these cases illustrate is the increased role played by amici curiae at the Supreme Court. So amici are friends of the court. These are non-parties who want to weigh in on the dispute. The only requirement here is that the amicus has a general interest in the case, and that's defined pretty broadly of what an interest may be. For the last 10 years, my colleague Anthony Franz and I have conducted an annual review of Supreme Court amicus practice for the National Law Journal. We found that nearly every case that's argued these days has amicus participation, and they average more than 10 briefs per case. The record was 156 in the marriage equality cases in 2012. To put that in historical perspective, in the 1950s, you were seeing less than one brief per case. Roe versus Wade, a blockbuster of its time, had 23. Brown versus Board, 6, just 6. That's all changed. The Simon and Philip cases have generated amicus briefs so far from legal historians, professors, former government officials, another foreign state, and the United States. And those are just the ones that have urged reversal. We're going to see some more in the coming weeks. So why is this important? Well, it's because of the role that amici play today. They highlight the practical effects on the ground, or they offer different perspectives or lenses to view the issue that the court is deciding. They often introduce complexity or nuance that the parties either don't have time or interest to bring to the court's attention. You don't always see these briefs. You certainly don't often hear about them, but they're there, and they're there in record numbers. Amici are trying to tug the justices in one way or the other. So think of it like an ocean tide. It may be difficult to estimate the impact that a single wave has, but the collective effect is undeniable sort of in sculpting the landscape. That's the way I think of the amicus practice in the Supreme Court right now. The third theme is the court's evolving views on access to justice. Look, no one disputes that Holocaust victims deserve justice. Of course they do. But where should they go for that justice? Why here? What makes a US court more appropriate to hear those claims? That question becomes especially acute when another court or system is ready, willing, and able to hear that same claim. Who gets to decide? And this is at the heart of the Simon and Philip cases. Several European countries have established robust remedial programs to provide some measure of compensation to Holocaust victims. And they've done so with the support of the US government. Those countries have both the responsibility and I would say the moral duty to provide justice to those who were injured in their borders. And should US courts be available to circumvent those measures? So with this concept of access to justice in mind, you'll recall that the Supreme Court has taken a number of steps in recent years to rein in expansive jurisdictional theories. So we've seen this most dramatically in the personal jurisdiction cases, where Justice Ginsburg has led the charge to limit jurisdiction over foreign defendants. And you may hear this theme again when Judge Pooler talks about the Nestle and Cargill cases. Who decides those disputes? So when you think about the court and access to justice, remember that it's not just access versus no access, but the question increasingly is access here or access there? And the Supreme Court seems to increasingly be answering there. So with those three themes, flexibility, the amici practice, and the question of access to justice for where, I think you've had your serving of legal vegetables from the advocate's perspective. And like all of you, I want to hear about the blockbuster cases, starting with my friend Upneet Bhatti, who's going to talk about the Affordable Care Act. Thank you all, and I look forward to the Q&A a bit later.
Thanks so much, Reeves. Upneet, you're next.
Thank you, Professor. Thank you, Reeves. It's always a daunting task to follow your boss and mentor, but I'll do that. So I'm going to be discussing the Affordable Care Act cases, California versus Texas and Texas versus California. Two cases were consolidated. The broad topic here is the individual mandate and the general constitutionality of the Affordable Care Act. Now, this case has a lot of huge implications with taking away insurance from several millions of people, many with pre-existing conditions. It also deals with the practicalities of doing away with the Affordable Care Act because it's so ingrained in the American healthcare system at this point. So by way of background, we all know the Affordable Care Act was passed in 2010 under President Obama's presidency. It's quite controversial. It made its way up into several courts, including the Supreme Court in NFIB versus Sebelius, forever ingrained in my mind because that came out the first year of law school for me. And a majority of the justices held that the individual mandate was not a proper use of Congress's Commerce Clause or necessary and proper clause powers, although Justice Ginsburg did disagree with that. But nonetheless, it held that the individual mandate was constitutional under the tax and spending clause. We did have a dissent from Justice Scalia, joined by Justice Kennedy, Thomas, and Alito. And they said the individual mandate was unconstitutional under the Commerce Clause, but also that reclassifying the individual mandate as a tax rather than a penalty was rewriting the statute, which is not permissible under any kind of judicial power. It also noted, the dissent also noted that the Affordable Care Act exceeded its constitutional powers in many ways. And so that's important to note now because of those four justices, two still remain on the panel. And Judge Barrett, as Adam indicated, has also supported Justice Scalia's interpretation of the ACA. Let's fast forward to 2016. We see President Trump campaigning to repeal the the Affordable Care Act during before the elections, and after his presidency, we see the Republican caucus coming in and trying to figure out how to replace this bill, but in a very terrible way that completely collapsed and failed. Nonetheless, Republicans used the tax bill, the Tax Cuts and Jobs Acts of 2017, to repeal the individual mandate, but they didn't amend the language in the statute. They just eliminated the tax penalty so that going forward, you weren't penalized for not having insurance. Now, the Supreme Court has interpreted the Affordable Care Act's provisions as giving folks a choice to either buy insurance or pay a penalty. However, now, in this case, we have plaintiffs arguing that because the Republicans didn't take out the language shall buy insurance, we're compelling folks to buy insurance. So essentially repealing the penalty made the ACA more coercive, not less. And that kind of coercion exceeds Congress's power. So we see Texas led 19 other states in a federal lawsuit in the Northern District of Texas. Two main arguments were made. One, that the repeal of the individual mandate essentially made it more coercive for folks. And two, they argued that the $0 mandate is so critical to the continued operation of the Affordable Care Act that the unconstitutionality of that individual mandate renders the rest of the ACA invalid. Kind of a stretch, but 3 judges, including the district court judge and 2 judges on the Fifth Circuit, went with those arguments. So in the Northern District of Texas, we see District Judge Reed O'Connor affirming the plaintiff's opinion and saying the individual mandate is unconstitutional. And second, because it's such an essential part of the law, it's not severable. And so the entire law is unconstitutional. Now the Fifth Circuit, where we had Judges Elrod, Engelhardt, and Judge King, we see them taking a little bit of a different approach, but essentially affirming the district court. So we see them finding standing, saying individual plaintiffs and the state plaintiffs both have standing, and that the individual mandate as it stands is unconstitutional. However, in interpreting the severability issue, the court said the district court didn't do enough to explain how they reached the severability issue, and so it sent it back. The dissent by Judge King also noted that standing seemed a little ridiculous here because any kind of harm is self-inflicted by plaintiffs, and that a $0 mandate is not really going to do anything or harm anybody. So the issues now we have in front of Supreme Court are standing, merits, and the severability issue. I'm going to focus on the severability issue because that's what received a lot of attention, and based on a couple of opinions that we've seen in the last term from Justice Roberts and Justice Kavanaugh, things could be decided on that basis. So with Justice Ginsburg's demise, this case didn't seem, before that it didn't seem all that important, but now we see this case maybe becoming a little bit more important with, as Adam pointed out, not Justice Roberts playing a central role, but Justice Kavanaugh probably playing a central role given his take on standing and severability issues. So we've seen Justice Kavanaugh focus on standing in many other opinions, but also he's also been thought to support the ACA given his past decisions. So for instance, when he was in the Court of Appeals, he decided, he had an opinion in the Seven Sky versus Holder case in 2011. He filed a dissent there saying he would have held that the court lacked jurisdiction to hear the case regarding the Affordable Care Act because the Anti-Injunction Act bars any pre-enforcement lawsuit. He also issued a dissent in Sissel versus HHS in 2015 saying that an en banc hearing should have been granted in that case and that the court should rule for the government on the ground that the ACA originated in the House and thereby complied with the origination clause. So we haven't seen anything from Justice Kavanaugh suggesting that he wants to tear down the entire statute, and his viewpoint and his support of the severability doctrine also leads us to believe that he'll probably vote with the liberals here. We've also seen him in Barr versus American Association of Political Consultants in 2020, just a recent opinion where he said, he noted the court's decisive preference for surgical severance rather than wholesale destruction, and that constitutional litigation is not a game of gotcha against Congress, where litigants can ride a discrete constitutional flaw in a statute to take down the whole. So he really does support the severability doctrine, along with, I would say, Justice Roberts and Justice Alito. On the other hand, we have Justices Thomas and Gorsuch. They've unfortunately have expressed a growing discomfort with the doctrine, raising concerns about the court's power to just blue pencil in statutes and criticize the use of that doctrine so broadly. So we have a few takeaways from this case. One, the arguments seem pretty frivolous, and a lot of folks have, on both sides, have criticized the Fifth Circuit and the district court decisions and the arguments that are being presented, but nonetheless, it's up in the Supreme Court. Second, I would say that the severability issue is, as I mentioned before, is important, especially given the court's use of that doctrine in Barr and in another case in the last term. But we also must note that 4 justices have thought that the Affordable Care Act in totality is unconstitutional. And again, as I mentioned before, 2 of those justices are still on the panel, are still on the court, and we have Judge Barrett as a possible nominee. The other thing to note is that oral arguments in this case are going to take place on November 10th, so after election. So the court might decide to wait until maybe we get a new presidency and see what the Democrats, if they take the Senate and the White House on November 3rd, we'll see whether they're going to do that, whether they're going to do anything with this case and maybe try to get rid of it by passing some sort of bill. Maybe they'll change the language, maybe they'll impose some sort of nominal tax so that the mandate isn't $0, maybe it's $5 or something like that. But we'll see when the court decides that and whether the Democrats can get away with this lawsuit. And that's it for me. Thank you.
Thank you, Upneet. Next, we have Judge D'Agostino. So there she is. The floor is yours.
Thank you very much. It's my pleasure to be a part of this program this afternoon. I have to say that I had to go to the tissue box a couple times on my desk when the video tribute was being played for Justice Ginsburg. Justice Ginsburg was assigned to our circuit, the Second Circuit, as our justice. And as a result, since I have been on the bench over the last 10 years, she came to all of our circuit meetings, and she would have dinner with us in the evening, and then the next day give us a report on any of our cases that had been to the Supreme Court, and also just give us a general report about what went on in that term at the Supreme Court. And several years ago, I was tasked with sitting a few feet away from her and asking her about her love of opera. I was a nervous wreck, but I learned very quickly if I just asked her one question about the opera, she could take up the rest of the time. So I managed to get through my interview of Justice Ginsburg. So let me move quickly to my 2 cases, the first of which is Fulton versus City of Philadelphia. This is a case that was decided by the Third Circuit in April of 2019, and it is scheduled for oral argument on November 4th at the Supreme Court. The facts are pretty simple. This is a case in which the Philadelphia Inquirer did a news story in Philadelphia about the fact that the city had a contract with 2 agencies for the placement of foster children, and that these 2 agencies would not allow gay and lesbian couples to apply to foster. When this came to the attention of the Philadelphia Department of Human Services, they immediately contacted the 2 agencies, one of which was Catholic Social Services. And they said, is this true? Are you excluding gays and lesbians from being considered to foster children? And both agencies said, yes, we are, because we have sincerely held religious beliefs that marriage is to be between one man and one woman. And you cannot compel us to go against our religious beliefs to place foster children with gay and lesbian couples. Soon thereafter, the city began calling other agencies that they had contracts with, both religious and non-religious, and asking if they had similar policies. The city tried to work things out with Catholic Social Services, tried to see if they would change their ways. The city maintained that they had anti-discrimination laws that would prevent them working with Catholic Social Services if they would not stop their discrimination. But as a result, talks were not fruitful, and Catholic Social Services brought this action against the city of Philadelphia, claiming that they were attempting to violate Catholic Social Services' right under the Establishment Clause, free speech, and under the Pennsylvania Religious Freedom Protections Act. The holding in the case in the Third Circuit was that indeed, because there was an anti-discrimination law on the books, that the city did have the right to not renew its contract with Catholic Social Services and not to utilize Catholic Social Services. And also, the Third Circuit ruled against CSS and refused to grant a preliminary injunction. The city felt that their policy was non-discriminatory. They claimed that it was neutral, and the court held that it was neutral, that it was a generally applicable law, and it was not meant to target the Catholic faith. And the holding below was that CSS failed to prove that they were targeted, and they failed to prove that the anti-discrimination regulation was indeed motivated by ill will. Now, before I go a step further, I want to tell you that I have a case very similar to the Fulton case. And I rendered a decision on this case several months ago. I did not grant a preliminary injunction request that had been brought by a Christian adoption agency. That case has the same concerns about that agency because of sincerely held religious beliefs, not adopting children out to gays and lesbians. Because that case is still pending before me, I'm not going to talk about it further, but if you do want to take a look at that case after today, the name of the case is New Hope Family Services versus Sheila Poole, who is the acting commissioner. And my decision is at 387 F sub 3rd 194. Again, I was reversed by the Second Circuit. The Second Circuit case number is 19-1715-CV. A mandate was received by me on that case on August 12th of this year. So you will see similarities, but that is all I will say about the case at this point. Getting back to the Fulton case, I think that we have to keep in mind that we will have to look back briefly at two other Supreme Court cases, the Masterpiece Cake Shop case, and also the case involving the city of Hialeah and the religion that wanted to worship animals by, essentially burning the animals in a religious rite. But we also have to look back at a case that Catholic Social Services and those who submitted amicus briefs for the Supreme Court on this case, they really want a look back on this case, which is called Employment Division, Department of Human Services versus Smith. Now, this is a case that was decided back in 1990, and Justice Scalia wrote the decision. It's not possible to go further with Fulton, I think, unless we just take a quick look at this case. And as I said, CSS and others would like the Supreme Court to look back on this case because it contains some very sweeping language about whether or not government can curtail religious activities. Very simply, the case involved two gentlemen who were Native Americans, and they ingested a drug called peyote in their religious rites as Native Americans. Their employer found out about it and fired them because it contains a hallucinogenic. And not only were they fired, but when they applied for unemployment, they were refused unemployment. The court, through Justice Scalia, was asked whether or not it was essentially against the law that they could not receive their unemployment benefits simply because they used peyote, which clearly was an important part of their religion and the way that they celebrated their religion. When I talk about sweeping language in the decision, ultimately Justice Scalia in his decision said, well, the use of peyote is illegal. It's a prescribed substance under the law of Oregon. It is a crime to use it. But the language that I just want to read to you from the decision is as follows from Justice Scalia. We have never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. Conscientious scruples have not, in the course of the long struggle for religious toleration, relieved the individual from obedience to a general law not aimed at the promotion or restriction of religious beliefs. The mere possession of religious convictions which contradict the relevant concerns of a political society does not relieve the citizen from discharge of political responsibilities. And finally, subsequent decisions have consistently held that the right of free exercise does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability. So I think you could see why CSS and those who submitted amicus briefs want the Smith case revisited when the Supreme Court reviews the Fulton case, because obviously the city of Philadelphia is saying we have a non-discriminatory neutral law that is necessary to enforce because we have an anti-discrimination requirement in all of our contracts with the city. Courts, including the Third Circuit, look at a hostility issue, and that's why I mentioned Masterpiece Cake and I can never pronounce this case correctly, but the Lukemy case versus the city of Hialeah. We know from both the Masterpiece Cake case and the city of Hialeah case that courts will look at whether what the municipality did, what the government did, was done without willfulness, without an attitude about the religion. After all, in Masterpiece Cake, the Supreme Court looked at the way the commissioners spoke about the owner of the bakery. And in the decision, they were very, very hostile toward the way that baker was referred to by the commission below. In the Hialeah case, the city founders talked about the religion being banned in Cuba, that it's an unnatural religion, that this is a religion that we do not want in our state. And obviously in both of those cases, there was a finding that what government was trying to do was not neutral, and therefore the baker and the religion in the Hialeah case were not to be stopped in their sincerely held religious beliefs. Well, the same thing happened in the Fulton case. The Third Circuit did look at underlying comments that were made before the city decided to pull its contract. And I will tell you that in the Third Circuit, while they looked at these comments that were made, they found that they were not enough to say that the law was targeting the Catholics. But some of these statements included statements such as, why can't they just follow the teachings of Pope Francis? There was a statement by an archbishop that showed some general hostility toward the Catholic Church and its positions on gays and lesbians. But the Third Circuit said, well, we recognize that some of these comments were made, but we don't believe these comments demonstrate that there was religious targeting. So when this case is argued in the Supreme Court, I expect there to be many requests that the court go back and take a look at the Smith case and potentially find that Smith is no longer valid to the Fulton case. And I do think that the Supreme Court will look at some of the statements that were made by the individuals who ultimately made the decision to pull the plug on the contract with Catholic Social Services. And I mean, ultimately, the Third Circuit said that the city stood on firm grounds in requiring the contractors to abide by the non-discrimination policies when administering public policies. So that is going to be argued soon, and you will get a decision on that soon, I'm sure. I'm just about, I'm basically out of time, but I'll just, Pareda versus Barr is a case where you have to understand the difference between an indivisible statute and a divisible statute. And in Pareda, an individual who was in the country without sufficient documentation pled guilty or pled no contest to a Nebraska statute. That statute had some sections that required moral turpitude and at least one that did not. There was a modified categorical review of the statute, and ultimately the court below said, we can find no evidence as to what this individual actually pled to on the record. We don't know if he pled to elements that require moral turpitude or if he didn't. And you know what? It's on the immigrant to prove to us what he pled to, and therefore he is not subject to contesting his removal proceedings. The Defenders Association and the defense say that that is extremely unfair because in lower courts and village courts, town courts, city courts, it's often not put on the record what people are pleading to. And to force someone like Mr. Pareda to try to prove that he didn't plead to moral turpitude is just too much of a burden. And that case is supposed to be argued in October. I'm sorry if I ran over.
No problem. Thank you, Judge D'Agostino. Next, we have my distinguished colleague, Professor Paula Johnson.
Good afternoon. Good afternoon, Keith. Good afternoon, everyone. Thank you for inviting me to participate on this panel with all of the other very distinguished colleagues and guests. I was especially interested in hearing Adam Liptak's comments earlier. And I want to begin by saying, well, one thing about the tribute to Justice Ginsburg. And I want to thank, many hands went into that. And so I appreciate the acknowledgement, but also that my research assistant, Diane Jahangani, helped to do. But I want to say that as we remember Justice Ginsburg's passing, that our society and all of the politics that are surrounding not only her passing, but also now the vacancy of her seat on the Supreme Court and what that means to us. As we think about these cases that are coming before the Supreme Court in just days now, many of them address some of the most critical issues in our society. The area that I'm going to be focusing on in just a moment has to do with the criminal law and criminal procedure. And this is happening at a time in our country when we are especially riven by issues having to do with the killings of several people of color over this past summer at the hands of law enforcement. And those members of our society and our community were unarmed. And so it is raising serious questions for us about the way in which our criminal justice system operates, particularly where we are concerned about issues of race and racial disparity. We know that just in the last couple of days, the Attorney General in Kentucky revealed the grand jury's decision in the Breonna Taylor case. And that once again has caused quite a bit of concern and dismay and frankly anger across the society as to how the decision could be made that there would not be any criminal charges against the officers who were responsible for her death. And so as we're thinking about these issues as they're coming before the Supreme Court, these things loom large for us because they affect us not only in terms of what the rule of law is going to be determined to be, but also the application of that rule of law and whether or not that's going to be considered something that is racially fair or racially disproportionate. And so we have to consider the context in which these events happen and continue to be concerned about the way in which the criminal law is discharged, not just the way in which it's written. I want to begin with the three cases that I have on my palette, and one of the first is a case called Torres versus Madrid. And this case involves, it comes out of the 10th Circuit and particularly out of New Mexico. And it involves a woman, Roxanne Torres, who had been visiting friends or associates in an apartment complex parking lot. The police in New Mexico were concerned about drug trafficking of someone whom Ms. Torres knew and had been suspected of drug trafficking, but not Ms. Torres herself. And so when the police came to try to execute a warrant against the other party whom they had suspected of this activity, they also stood by Ms. Torres's car. And when she began to leave, she began to drive her car away. The officers, two of the officers, Janice Madrid and Richard Williamson, fired at her car. Now, all evidence indicates that Torres was not armed, but she was concerned because the officers were in plain clothes, and her testimony down below said that she thought that they might be carjackers because she wasn't aware of who they were or why they were there surrounding her car. And so she took off in her car. And the officer shot after her car, and so shot multiple times. I think it was something like 10 or 13 bullets, several of them striking her in the back and paralyzing her on one side. She was able to continue to get medical assistance. She drove herself to get medical assistance, and the police ultimately reached her at the hospital in Albuquerque, and then charged her with evading an arrest. Under these circumstances, Torres filed a Section 1983 claim against the officers, alleging excessive force and seeking damages for her injuries for the constitutional violation under the Fourth Amendment. The district court dismissed her claim by summary judgment, stating that she did not have an argument that her Fourth Amendment rights were violated. Now, the basis of the Fourth Amendment claim was that there was an unconstitutional seizure that had taken place. Now, the argument for the reason why there was a seizure is important to understand, and that is because it comes out of a common law understanding of arrest. And so under the common law, where there is an arrest, the Supreme Court has said this is the quintessential seizure. And so what complicates the issue is that the officers did not physically take Ms. Torres into custody, even as they shot at her and struck her with bullets. But Supreme Court precedent finds that there is a seizure where officers attempt to act with intention to stop someone and to get them into custody, where they may have shot at them or otherwise may have gone after them. The precedents do not require that someone be physically held into custody. Although I have to say, this is the contentious point in this case, because law enforcement or the government's argument is that seizure indeed does mean that there has to be physical custody, that someone was actually subdued, as opposed to someone who may have continued to flee or who may have escaped. Now, the primary precedent in this area is a case called Hodari versus California. And in that case, the Supreme Court adopted the common law definition of arrest, and that is where it wasn't required that there be a physical capture of someone, but where the police acted with the intention of capturing someone, that constituted a seizure. And so here, where the police acted to shoot at Ms. Torres in an effort to stop her in order to capture or subdue her, the Hodari analysis would find that that would constitute an arrest, and if that constituted an arrest, then there was a seizure. And so the follow-up to that argument is that there was excessive force, and that was the violation under the Fourth Amendment. The state is arguing, quite to the contrary, that the language in Hodari that recognized arrest under the common law concept of that event was dicta, but not a holding. And so they refused to accept that language as a holding, and found instead that there had to be actually a physical capture in that case. The 10th Circuit affirmed the decisions down below. And so this matter is now making its way to the Supreme Court. This case is coming up rather quickly to the Supreme Court because oral arguments are scheduled for October 14th. And so this is going to generate a great deal of interest very early in the court's term. Now, one other aspect of this case that I think is important to mention, and again, it's important within the context of these issues that we're seeing that have occurred during the past summer, and that is assuming that there well, whatever the court's decision may be as to responsibility for the shooting, and so in finding, whether or not there was indeed an arrest and whether or not that constituted a seizure under the Fourth Amendment, undoubtedly the issue of qualified immunity is also going to be raised in this case. And indeed, it's one of the issues that has been briefed in the cases. And qualified immunity is a doctrine that has allowed governmental officials, particularly law enforcement actors, to have limited and in some instance no liability for any excesses that they may commit, including excessive force with respect to attempts to arrest someone. And so this is a very contentious issue. This doctrine itself was created by the Supreme Court, and there are many calls to restrict it because of its disproportionate impact in holding law enforcement accountable for their actions. The next case I want to talk about just very quickly is Borden versus U.S. And in the Borden case, this is the situation in which the defendant in Tennessee was held under a statute as being a third-time offender under a violent offender statute in that state. And so he was charged with a reckless assault offense. And what becomes important about that was that he had two prior offenses. Now, those two priors were offenses in which the mental state requirement or the mens rea requirement was intention or knowledge. But the third offense was one in which the mens rea element was recklessness. And so he argued that he could not be held under a statute for an offender as a repeated offender because the third offense didn't meet the requisite mental state element. Now, in the interim, while his case was on appeal, another case was decided in Tennessee, which amended the statute and indeed accepted recklessness as a mental state that could suffice for this statute to hold someone liable. He has argued, the defendant here has argued, that to hold him in that way under the repeat felon statute would constitute an ex post facto exercise of the law. And so he is challenging that not only based on the matter of the mental state element, but also whether or not its retroactive application to his case would constitute a constitutional violation under the ex post facto laws, meaning that his behavior, while not innocent, did not meet the mental state requirement of intention that had been the case prior to the court's decision in the interim. So that is going to be an interesting case, as well, of course. And one of the reasons why in teaching criminal law that I find the Borden case, particularly interesting is because for first-year students, you know, we don't often get cases that focus on these basic elements of criminal law, such as actus reus and mens rea. But here's a case that's going directly before the Supreme Court, where the very question is what mental state is required in order to hold someone liable for this case, and then for this harm, and then what are the implications of mental state as to the punishment that can be meted out as a result of that. So that by the time that we're doing first year criminal law in the spring semester, perhaps the court will have decided that, and we can certainly discuss it in either event. Let me you know, try to quickly go through the last case in the series that I wish to discuss with you, and that is Jones versus Mississippi. And the Jones case is one in which a youthful offender, youthful at the time, 15-year-old, was convicted of killing his grandfather as a result of an altercation that they had. He was living with his grandfather as a result of being removed from his own home and having spent considerable time in foster homes, and generally coming from a rather abusive environment. The grandfather had complained that he had his girlfriend in the house. They argued in the kitchen, and so he took a knife and stabbed his grandfather several times, and subsequently turned himself in. The primary issue in this case is an Eighth Amendment concern. The Eighth Amendment prohibits cruel and unusual punishment, and the significance of it to this matter is that the state of Mississippi sentenced him to life imprisonment without parole. And so the Supreme Court had previously ruled that youthful or juvenile offenders could not be held with a lifetime sentence without parole unless they fit into a narrow category of offenders who were deemed to be permanently incorrigible. And that is the language that comes out of the cases in Miller versus Alabama and in Montgomery versus Louisiana, where the court squarely faced the issues of what kind of sentences there could be for youthful offenders. And the underlying analysis of those cases, coming not only from law, but also from other disciplines, including psychiatry, developmental areas, suggest to us that younger people are not fully formed yet in terms of their intellectual abilities, in terms of their abilities to make certain decisions that are considered to be permanent kinds of decisions, that their ability to discern distinctions and severity are quite limited. Also, that in terms of the rehabilitative ideal, that youthful offenders are considered to be different from adults by virtue of their youth. And that is that they cannot be said to be people who are not capable of rehabilitation. So that life sentences without the possibility of parole are deemed to be not in order except for a very narrow class of juvenile offenders. The state argues to the contrary, that they have the discretion to make that determination and mete out that kind of sentence, and without having to make that specific determination. The advocates on the side of the youthful offender argue that the Mississippi officials did not make a specific determination that he was considered to be permanently incorrigible. And they asked for that to be a finding in a rehearing, sentencing hearing in his case. And the state argues that that is not necessary, that those particular words are not required to be used, and indeed those particular factors are not required to be found, as long as the state deems that in this case, he is someone who deserves the sentence of life without parole. So once again, among the issues that concern us have to do with the permanency of a sentence with respect to youthful offenders, but also the disproportionate impact of harsh penalties as it relates to the ways in which race is implicated in these cases. Now, in this particular case, the defendant is white, but the data overwhelmingly shows that harsher penalties apply when the defendants, youthful defendants, are youth of color. And so it raises serious issues about, again, how the criminal justice system will operate, whether it will be racially fair or racially disproportionate, in addition to addressing these legal doctrinal issues. So I will stop there and look forward to speaking with folks during our question and answer period. Thank you very much.
Thank you, Paula. Our final panelist is Judge Pooler. Judge Pooler?
Good afternoon to everyone. It's a pleasure to speak with you today regarding a pair of cases that will further define the contours of the Alien Tort Statute. The ATS provides that the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or treaty of the United States. It was enacted in 1789, and it was evoked in only a handful of cases until the 1980s. The Second Circuit, on which I sit, played a key role in its revival with our decision in Phil Artiga versus Peña-Urala. Paraguayan citizens Joel and Dolly Phil Artiga sued Americo Norberto Peña-Urala, also a Paraguayan citizen, for wrongful death. The plaintiffs alleged that when Peña-Urala served as a local police official in Paraguay, he tortured one of their family members to death. The Second Circuit held that state-sponsored torture violated international human rights law, making it a violation of the law of nations under the ATS and allowing American courts to exercise jurisdiction over the plaintiff's claims. Well, Phil Artiga encouraged a wave of ATS lawsuits, with corporations becoming the focus of complaints brought by human rights advocates against multinational corporations, alleging that corporations were complicit in abuses committed in the course of joint projects undertaken between the corporations and host governments. As you might expect, the corporations resisted such litigation, arguing that the ATS did not allow plaintiffs to hold corporations liable for abuses occurring abroad. The Supreme Court first addressed the issue in Sosa versus Alvarez Machain. There, the Supreme Court stated that courts could exercise jurisdiction under the ATS only where it involved an alleged violation that rested on an international law norm accepted by the civilized world and defined with a specificity comparable to the features of the three torts that fell within the scope of international law violations when the ATS was enacted in 1789. And those three were violation of safe conduct, infringement of the rights of ambassadors, and my favorite, piracy. The court addressed corporate liability in a short footnote, stating that in determining whether an international law norm have become sufficiently accepted so as to support ATS jurisdiction, a related consideration is whether international law extends the scope of liability for violation of a given norm to the perpetrator being sued if the defendant is a private actor, such as a corporation or individual. The Second Circuit next took on the issue of corporate liability in 2010 when it handed down Kiobel versus Royal Dutch Petroleum. That's a case that lingered in the Second Circuit for many years, and every one of my colleagues, including myself, had a little piece of it. Motions, amendments, we all lived with Kiobel for a long time. And there, a group of Nigerian nationals residing in the United States sued Royal Dutch Petroleum Company and other corporations, alleging that the defendants worked in concert with the Nigerian military and police to beat, rape, kill, and arrest Nigerians protesting the corporation's oil drilling practices. The Second Circuit dismissed the complaint, holding that the ATS does not provide subject matter jurisdiction for civil actions against international corporations for violation of customary international law. The Supreme Court granted certiorari to address the corporate liability question, but it never reached the issue. Instead, the court asked for additional briefing and re-argument and dismissed the claims on the ground that the presumption against extraterritoriality applied to the ATS, which is very important in the cases they took this year. To obtain jurisdiction under the ATS, the court held plaintiffs must show that their claims touched and concerned the territory of the United States with sufficient force to displace the presumption against extraterritoriality. The court concluded that plaintiffs failed to do so. None of the parties were U.S. nationals, and all of the alleged conduct occurred outside the United States. This is in Kiobel. The defendant's only connection to the United States was their listing on the New York Stock Exchange and an affiliated office in New York, whose sole purpose was to explain the defendant's business to investors. The court was largely silent on the issue of corporate liability that was the focus of the Second Circuit's opinion, stating only that mere corporate presence does not suffice to rebut the presumption against extraterritoriality. The Supreme Court thus left the Second Circuit's Kiobel holding on corporate liability intact, providing a pathway for the question to return to the Supreme Court in Jessner versus Arab Bank, also a Second Circuit case. Petitioners were some 6,000 foreign nationals who were plaintiffs in 5 lawsuits filed in New York between 2004 and 2010. Petitioners alleged that they or their families were injured or killed by terrorist activity in the Middle East, and that Arab Bank helped finance those activities in violation of international law. Plaintiffs alleged that Arab Bank used its New York branch to clear dollar-denominated transactions that benefited the terrorists and to transfer funds from a Texas-based charity, the District Court dismissed their claims on the grounds that corporations could not be sued under the ATS, and the Second Circuit affirmed. The Supreme Court granted cert. Writing for a 5-4 plurality, Justice Kennedy framed the issue as whether common law liability under the ATS extends to a foreign corporate defendant, rather than addressing the issue of corporate liability generally. Kennedy analyzed SOSA as posing a 2-question test: whether the allegedly violated international law norm is sufficiently specific, universal, and obligatory, and whether judicial caution mandates dismissal in the absence of authorization by the political branches. Finding sufficient doubt on the first question, he answered the second question in the affirmative, closing the door to suing foreign corporations in the United States under the ATS. Which brings us to the two ATS cases under consideration by the Supreme Court. U.S. corporations. Nestle USA versus Doe 1 and Cargo Incorporated versus Doe 1. These cases were decided together by the Ninth Circuit and consolidated for argument before the Supreme Court. Oral argument is scheduled for December 1st. Plaintiffs in both cases are former child slaves who allege that between the ages of 12 and 14, they were trafficked from Mali to cocoa plantations in Cote d'Ivoire. Their plaintiffs alleged they were forced to work without pay for 12 to 14 hours a day, given inadequate food and shelter, and subjected to intimidation and torture. Defendants Nestle and Cargo did not own or directly operate these plantations, but the plaintiffs alleged that both corporations exercised a high degree of control over the global cocoa industry, and they actively and knowingly aided in the use of child slaves in an effort to keep cocoa prices low. The district court dismissed for lack of jurisdiction, but the Ninth Circuit reversed as to the domestic corporate defenders. It found that plaintiffs adequately pleaded conduct that touched and concerned the United States because while the slave labor all took place overseas, plaintiffs pledged that it was organized and facilitated from defendants' United States headquarters. The panel did not undertake any real analysis of Gessner, merely noting that Gessner did not eliminate all corporate liability under the ATS, and we therefore continue to follow Nestle's holdings as applied to domestic corporations. An attempt to take the case in bank in the Ninth Circuit failed. In dissenting from the denial of rehearing, Judge Bennett noticed that while Gessner had expressly left open the question of domestic corporate liability, Justice Kennedy had opined that corporate liability was not a universal norm in international law and just failed the first prong of the Sosa test. And while Justice Kennedy did not garner a majority for that proposition, Justice Bennett argued that the natural next step following Gessner was finding corporations are not liable under the ATS. The Supreme Court granted cert in these two cases on two issues. Whether an aiding and abetting claim against a domestic corporation brought under the ATS may overcome the extraterritoriality bar when the claim is based on allegations of generous corporate activity in the United States and where the plaintiffs cannot trace the alleged harms which occurred abroad at the hands of unidentified foreign actors to that activity, and whether the judiciary has the authority under the Alien Tort Statute to impose liability on domestic corporations. Given the current composition of the Supreme Court, it seems likely that ATS jurisdiction will continue to be narrowed. While serving on the D.C. Circuit, Justice Kavanaugh took the position that the ATS does not apply to claims brought against corporations, and it seems unlikely he will change course now. Disallowing ATS claims against corporations will require human rights advocates challenging corporate behavior to switch to the political arena, perhaps through economic sanctions. Plaintiffs will also retain the ability to bring claims against individuals under the ATS, and if torts are committed under color of law, under the Torture Victim Protection Act. That's where it stands. I expect a narrowing, but we'll all be able to find out after the court decides these two cases. Thank you for your attention.
Thank you, Judge Pooler. We're now entering the Q&A section of our panel discussion, and we will be proceeding in gallery format, which means that you should be seeing the faces of all the panelists showing up as they switch on their video cameras. I am monitoring the Q&A feed, and I will be taking up questions and addressing it to the panel or to individual panelists as appropriate. Before we begin with our Q&A though, As promised, let me let those of you who are seeking CLE credit for today's event know the second code which you need to enter on your affirmation form. That code is SC21. That's SC21. That code's also being put into the chat by Kristen Duggleby, so you can see it written there as well. Okay, the first question that we have, I think is really kind of a question that could be addressed by any of the panelists. The questioner notes that last time there was a vacancy on the court seemed to work to avoid badly fractured decisions and decided a number of cases on quite narrow grounds. So do you think, number one, that the court is likely during this period while there's still a vacancy to decide any cases in an incrementalist fashion? And if so, what consequences do you think that has for the particular area in which you've spoken about today? And what we can do is use the old-fashioned method of just raising your hand on the panel if you'd like to speak, and I'd be happy to call on you. So would anybody care to take a stab at that first question?
I'm going to use Judge Pooler as a lifeline.
Okay. Yes, Judge Pooler.
I don't think in the area of holding corporations liable that a new justice will make any much of a difference. I think there are 5 solid votes to let corporations off the hook. I'd be interested if Reeves agrees with that. He gave you a tip to listen to my talk, and I don't see any future for holding corporate defendants liable. What do you think, Reeves?
So it's a good question, Judge Pooler. The Supreme Court this is now the 3rd opportunity they've had to rule on domestic corporations, and they've now punted twice. They found some other way to resolve the case. This case not only has the other question you mentioned about the scope of extraterritoriality, but the United States government in its amicus brief has tried to inject a 3rd issue, which is whether aiding and abetting can even apply in the ATS context. And so if there is not a 5th vote, there are a number of other off-ramps for this particular case. And what we saw with the vacancy of Justice Scalia's seat was some tempering of the decisions, but more importantly, some tailoring of the cases that the Supreme Court granted. So that seat was vacant for quite some time. The most important thing the Supreme Court does sometimes is deciding which cases to decide. And we saw what we called a sleepy term in the period after Justice Scalia, because I think the Supreme Court was consciously avoiding taking the more contentious 5-4 cases. It's also a matter of pure mathematics. It takes 4 votes to get cert. There's 1 less vote sitting on the court today. And so whether it's a prediction of whether you can have your 5 or whether it's you can just count to 4, I do think that we're going to have, at least depending on how long the seat is open, some moderation on the most contentious cases.
Anyone else want to weigh in on that? All right, we have a second question that looks forward. Oh, yes, Paula.
Yeah, thank you. I just wanted to say that I think in some of these cases, I think it might behoove the court to actually have rehearings in some of them because the issues are so laden with with value, and the areas that I've been speaking about today in particular, I think they are not unaware of this moment in our society. And I think that if there's any question as to these underlying issues, that it's also not, unprecedented or unusual for them to actually have the parties come back and re-argue some of these issues. It could be the case with the Affordable Care Act and a number of these other areas. But I wouldn't be surprised if that were the case once someone is seated as that 9th justice. Thank you.
Thank you, Paula. Well, our next question actually looks forward to a vacancy being filled. and notices that there's not only a number of cases with direct immigration consequences, there are some cases concerning immigration in a criminal context, and of course there are criminal law cases, as Paula noted in her presentation. The questioner is wondering, given the likely options of who's to occupy that 9th seat, do any of you anticipate a systematic shift where one party will find more favorable treatment in the court than the other? In particular, will the government now be more successful in its litigation, or will we find that, perhaps surprisingly, that defendants will fare better? Do we anticipate that a court will, looking forward after the seat is filled, be more favorable to one kind of party or another?
Well,
Any takers? Yes, Judge D'Agostino.
I think that how the Pareda case is decided is going to tell us quite a bit, because there is such a divergence of opinion about what should be done with this case. The briefs submitted by the government are very, very clear cut. They do not want this illegal alien to have the opportunity to refute his removal proceeding, because they steadfastly claim that he was convicted of a crime of moral turpitude. And not only that, but the Attorney General is taking the position that although the lower court and the immigration judge could not tell exactly what he pled to, that's okay, because it's incumbent upon the appellant to do that. And what the defense is saying is that's impossible. You're giving Mr. Pareda and his attorneys an impossible task. So I think that this case will be one indication of where the court is going in some of these immigration cases.
Thank you. Other thoughts on the panel?
Could I just say quickly,
Yes, Paul.
Keith, I just want to say this, because again, I think just sort of channeling Justice Ginsburg for a moment. In the Lilly Ledbetter case, in which she really took her colleagues to task for not understanding some of the realities of women's lives as it related to unequal pay and how someone would make that case within the statute of limitations. She was on the dissenting end of that case, so in the minority in that opinion. But she very directly said to Congress, the ball is in your court. And she used words almost to that effect. And so I think that something similar may happen in some of the areas that we're talking about here today, maybe particularly with respect to the immigration cases, because as we know, both Congress and the courts have been vacillating in terms of doing anything decisive about the issues, the legal issues, and so the treatments of people who are subject to the immigration laws. And I'm wondering if it might be another instance where the court says to Congress, you need to address this in a more decisive and definitive way, rather than continue to have these incremental cases keep coming before the court. And then it just becomes a very circular treatment of those issues.
Thank you, Paula. And as Adam Liptak mentioned, Congress might, depending on the outcome of the election, also weigh in by proposing an expansion of the court itself. We have another question here directed to our advocates on the panel. And so this would be for you, Nate and Reeves. Do you see, or your colleagues see, opportunities for change strategies, both in amicus and oral advocacy strategies, with this kind of likely change up in the court? And if you do see opportunities for change strategies, what changes do you see?
Nate, you wanna go first? So I don't know about the makeup of the court. And frankly, once I believe there's a number of justices who say that it takes a couple of years to settle into the role, right, until they've developed their jurisprudence. And so I don't anticipate some immediate transitions there. Interestingly, one of the effects we felt this past year was the telephone oral argument. So one of the 10 cases that Adam mentioned happened to be one that I was participating in. And the telephone argument and the ordering of questioning and the absence of the volleying, the backboarding that Adam was talking about, I think does affect the preparation for oral argument. You have a sense of, you already know the ordering of the questioners, and there's some momentum that builds from that because it's not jumping back and forth across either an ideological spectrum, it's done in order of seniority. And so we did feel some of that during the 10 arguments this past term. It also allowed the advocates to be more active backboards, I guess you could say. Certainly it's responding to questions, but I think that there was more agency during the argument to get out the affirmative points that I think had been lacking because there was not an opportunity for interruption. And so what I think you may see in terms of changing strategy, rather than if the court maintains this process, is more affirmative advocacy during arguments than you have seen in the past 10 years or so, since it's been quite a hot bench. But of course, the personalities matter here and the jurisprudence. And so depending on who is appointed or confirmed, whether we're talking about 8 justices, 9, or 13, certainly we're going to all have to pivot.
Thank you.
I think in terms of the makeup of the court, I hope the effect is not that folks that are able to take on pro bono projects, they sort of shy away from doing so just because of the cert possibility, the grant possibility. I hope that's not the effect in a lot of these cases, whether it's immigration, criminal context, all those cases. I hope that's not the effect. But in terms of strategy, I mean, at Warwick, we're heading towards 2 arguments soon, and seeing every day on messaging and whatnot how folks are going to address the remote virtual oral arguments that we've talked about. So yeah, it's not a concern, but it's definitely a change. A lot of folks are liking it as long as there's no background noise, but it's definitely a change, and it's a weird way to see the court. So they're definitely adjusting to that in terms of just the Supreme Court, also circuit court, district court levels, where all these courts are adapting to the new times.
Thank you. We have time, I think, for one last question, and maybe this is a good opportunity for a global reflection question, although maybe it touches most directly on the kind of high-profile, politically controversial cases that Upmeet and Judge D'Agostino discussed. And that's about the politics of the court. There's always a worry about the preservation of judicial legitimacy when you have such a hotly contested opening on the bench. And that's only amplified by having this vacancy occur, as Adam Liptak mentioned, during a presidential election. Do you have any concern or worry that whoever ends up on the court, that one of the casualties will be a broad acceptance of the court's legitimacy? Or do you have, I'm giving you a binary, but of course you should feel free to explode my binary. Or do you think that this legitimacy that's been more than 2 centuries in the making will survive the particular political crucible that we find ourselves in? And I'll take that as thoughtful consideration of the question. Judge Poole.
I think it's John Roberts' responsibility. He is an institutionalist, and he cares how the court is perceived. So I think it's his responsibility, whoever is added, whatever the court does, to try and convey to the population of this country that they are acting on the law and not on politics. And if anyone can do it, I think he can do it.
I have to agree with Judge Pooler. I think Justice Roberts knows his place in history, and that may very well be the preservation of our institutions. He has demonstrated that he understands that. And I like to be optimistic and say that the court, the Supreme Court, and all of our courts will continue to follow the rule of law, even though things can be contentious. You know, it's something I talk to my law clerks about all the time. I say, you know, if you ever even perceived that I would ever decide something based upon a political view, tell me, because I won't walk from this job, I will run from this job. And I think that most judges, I can't speak for other judges, but you know, I think that our judges always try to do the right thing. And I have no reason to believe that the Supreme Court, no matter who is on that court, will continue to do the right thing.
I'm going to go out on a limb and agree with the two judges here.
Wise move.
Take a big political risk, because we got to remember that for those 200 years, the justices have all been appointed by the prevailing president. To say that it's not, there's not been a political undertone throughout history is to misread it. But also I would remind the folks who are listening to one of the points I made in my remarks is that more than 90% of the cases aren't these blockbusters. They're not 5-4. In the year after Scalia's death, more than half of the cases were decided unanimously, and that's not unusual. And so there are a lot of opportunities for justices and judges of all political stripes to find consensus in the law. And this court has done a good job of doing so. And Justice Roberts, the chief, has done a terrific job of forming those alliances. And that gives me hope.
Thank you, Reeves. Go ahead, Upneet. I'm going to give you the last word.
Yeah, I agree with, I don't know if I deserve that, but I agree with Judge Fuller and Reeves and Judge D'Agostino. I think Justice Roberts understands that role. Unfortunately, I think some cases like the Affordable Care Act might be read by a lot as a political case, but I think Justice Roberts is going to do as much as he can to avoid that sort of interpretation.
Thank you so much. We are actually over time now, so I'm going to have to unfortunately bring to a close. So I'm going to have to close. I'm sorry. I'm going to have to turn this over. First, I'm going to thank our panelists for excellent presentation and thoughtful discussion. And I'm going to turn matters over to Kristen Duggleby, Director of Alumni Relations, to close our program. Thank you.
Thank you, Keith.
Thank you so much, everyone, for joining us this afternoon. It's been a great afternoon and a fascinating panel discussion. I just want to thank again our sponsors, Hancock and Estabrook, the Wallatus Law Firm, the NDNY Federal Court Bar Association, the Tully Center for Free Speech, the Institute for the Study of the Judiciary, Politics, and the Media, and the Syracuse Civics Initiative. Thank you to Vice Dean Bybee, Professor Goulden, Professor Gutterman, Adam Liptak, and all of our panelists for a fascinating program and discussion. And a special thank you to Shelley Childers, Executive Director of the FCBA, for your strong support. And thank you, alumni, students, faculty, and staff for joining us today. We hope you'll join us on Zoom again tonight at 6 p.m. for our Law Honors Awards ceremony to celebrate this year's distinguished alumni and faculty. We will honor 5 outstanding alumni and a beloved professor. We hope to see you there. Thank you.